If a person pulls a book off a shelf and then puts it back, the person didn't add a new book to the shelf. But what if a mining company removes and returns the same dredge materials into a navigable water? The court in National Mining Association versus U.S. Army Corps of Engineers answered whether redepositing dredge material was considered a discharge under the Clean Water Act. Under Section 404 of the Clean Water Act, the Army Corps of Engineers, or the Corps, issues permits for the discharge of dredged or fill material into navigable waters. The term discharge is defined as, quote, any addition of any pollutant to navigable waters from any point source, unquote. In 1986, the term discharge was refined to exclude de minimis soil movement that occurs during normal dredging operations. However, in light of the holding in North Carolina Wildlife Federation versus Tulloch, the Environmental Protection Agency, or EPA, and the Corps created a new regulation known as the Tulloch Rule in 1993. The Tulloch Rule removed the de minimis exception and expanded the definition of discharge to include any addition of dredged material into waters of the United States, including any redeposit. Redeposit is a process that occurs when material is removed from the water and then returned to the water in the substantially same location, also known as fallback. The Tulloch Rule was far-reaching and applied to almost all excavation or dredging activities. For example, if an excavation bucket lifted sand from a riverbed and some of the sand overflowed back into the water, any sand that fell back into the river would be considered incidental fallback. The National Mining Association and other trade associations filed a facial challenge to the Tulloch Rule. The associations claimed that the rule exceeded the Corps' authority under the Clean Water Act. The Corps argued that material in the water undergoes a legal metamorphosis when it's dredged. Dredged material then becomes a pollutant as defined by the Act and therefore requires a 404 permit. The district court granted a summary judgment in favor of the associations. The district court also issued an injunction to prevent the Corps from enforcing the rule. The Corps appealed to the United States Court of Appeals for the District of Columbia Circuit.